listeners, and welcome to Troutman's second episode in the Patent Post-Grant podcast series. My name is Maia Harris, and I'm joined today by two of my Troutman Pepper colleagues, Mike Goldman and Megan O'Gara, both in our Health Sciences IP practice group and both practicing out of our Rochester office. Mike and Megan, thank you so much for joining me today. Today's topic is supplemental examination. And I have to say, I'm really excited about it because as a litigator, this is just not something that I've run across before. And frankly, in my research, just to try and be at least conversational, if not knowledgeable today, I'm a little surprised that I haven't heard about it. So before we get really into the nuts and bolts, can you just tell our listeners what supplemental examination is at the highest level and why it might be something you think about doing?
Sure, I'll start us off. Thanks, Maya. It's Meg here. So this is very simply a mechanism for a patent owner to go back to the patent office and request to have the PTO consider, reconsider, or correct. That's the statutory language. Consider, reconsider, or correct information believed to be relevant to the patent. So because one of the possible outcomes is to cleanse a patent of inequitable conduct, it's probably the most notable outcome of this procedure. It's often thought of a way to quickly, I'm using my air quotes here, quickly dispose of those issues, hopefully on the part of the patent owner. But there's actually a really wide variety of information that can be cited as a basis for the supplemental exam. So that makes the procedure really useful far beyond the inequitable conduct sort of celebrity purpose of this procedure. And it can be used, as we'll talk about probably in a little bit during this podcast, it can be used for things like taking care of, clouds around enforceability or potential validity issues that you might see on the horizon. The supplemental exam just needs to be used for or based on something that the patent owner believes to be relevant to the patent. And that gives a lot of latitude to patent owners in making a request.
Yeah, so and you just identified actually two of the things that I thought were most intriguing about the process. And the first is this question of relevancy, because, as you identified, this relevance is a broad term. And if we're now kind of throwing anything that might be relevant at the patent office, kind of what are they doing with that? I mean, is that the standard that they're using to decide whether to proceed further or decide whether there's a substantial question of patentability with respect to any, particular patent that's being requested in this proceeding?
Sure. So really the standard for filing here, you've hit on an important topic, is not one that is ever examined. So information that is believed to be relevant, that's a statutory phrase, believed to be relevant to the patent, is permitted as a basis, but the USPTO never evaluates the request as to that belief of relevance by the patent owner. Instead, what's evaluated is a standard that's long been used by the USPTO, that has been long understood by all of us post-issuance practitioners, and it is the substantial new question of patentability standard that's been used in reexamination proceedings. And I feel myself talking too much. I'm going to hand this off to Mike to chat a little bit. He's certainly an expert on this topic, and chat a little bit about SNQs, as we call them, substantial new questions of patentability.
The same standard that is used in a reexamination is used in supplemental examination to decide how things move forward, or if they move forward. So on one hand, if there is a substantial new question of patentability, then the process will move into re-exam. And on the other hand, if the Patent Office determines that there is no substantial new question of patentability, the supplemental examination proceeding will end with a certificate that says that there was no substantial new question of patentability. And I think we've talked about the SNQ, or substantial new question of patentability standard, but I think it's important to actually enunciate the full expression, which is whether a reasonable examiner would consider the teaching or the information to be important in deciding whether or not a claim is patentable. And the important thing to remember, if you've been involved in re-exam and certainly in supplemental examination, is that a substantial new question of patentability can exist, but the patent examiner may not actually reject the claims on that same information when it comes time to consider that. The other thing to keep in mind with the substantial new question of patentability is it's a lower hurdle to clear than a level of materiality that would be required to prove inequitable conduct. So, for example, if we had an inequitable conduct assertion, the information that would be considered sufficient has to be but-for material. So, but for that information not being presented to the patent office, no patent would have issued in the first place is the standard.
And that's important just to go back to where, Meg, you first started, I think, because if the result of this is no SNQ, then presumably, and you tell me if I'm wrong, that kind of resolves any potential questions of inequitable conduct that might be raised. Is that fair to say?
I think that's fair on the basis of that information. I think we have to be clear about that part of the supplemental examination process, is that you are provided with a shield to inequitable conduct conclusions as to the information that was presented as the basis for the supplemental exam request. So there could be other combinations of art that could be a potential pitfall for you. And at the end of the day, it doesn't prevent someone from challenging your patent for validity on those same grounds. It just gives you a shield to inequitable conduct as to those particular pieces of information.
Just to be clear, whether the supplemental examination request ends with the finding that there is no substantial new question of patentability, or whether the case goes into reexamination, the cleanse effect still exists. So either way, you get the cleanse effect, but as long as you meet other criteria I'm going to talk about. But
that's fair. That's fair. That's a fair point, Mike.
Yeah, but clearly, if you have something that doesn't clear the hurdle of being a substantial new question of patentability, that there is an assertion of a lack of duty of candor around, then a denial or a determination that there was no substantial new question of patentability around that should be very, very much sufficient to avoid an inequitable conduct allegation.
Yes.
And those are fair points. But so the other thing, just going back to kind of where we started this conversation, that I was intrigued about is also we have kind of the breadth of relevance that you can provide anything that you believe to be relevant as part of this process, but also just the breadth of information, because as long as it's in written form, as I understand it, you can provide a variety of different pieces of information. It's not limited, for example, to publications.
Right. That's right. And that's what's really attractive about this procedure from a lot of different respects, is that you can cite your information, not just patents and printed publications, as you noted, which is what is typically the only thing that's acceptable with respect to re-exam is patents and printed publications. So you can cite anything that involves a ground of patentability. So it can be relating to anticipation and obviousness, but it can also relate to 101 issues, so patent eligibility issues. It can relate to 112 issues, so written description, enablement, and definiteness issues. It can relate to a public use or on sale ground. And you have to imagine all of the pieces of information that would support those various grounds of patentability. So it could be a declaration, oftentimes, an expert declaration or inventor declaration, where the item of information is actually discussed within the body of that declaration. It can be a transcript of a video. It can be other pieces of testimonial evidence that would support or form a basis for your ground for supplemental examination. And that's a really wide variety of information and provides so much latitude for the patent owner to request supplemental exam.
It does have to be in paper form, not so much because that's a requirement of the process, but it's the it's the essence of what goes on in the patent office. It's all on a written record. There's no interviews or anything else that are going to go on with this process. So everything has to be presented in a form that is in writing. So if you're talking about something that doesn't really exist in any kind of writing that you want to rely on, then a declaration of some sort about like some sales activity or something else might be necessary, because you're not going to have any other way of presenting that.
Right. And I presume you can provide then further explanation to the extent that you have, I don't know, advertisements or sales records or something like that need to be explained. You're not going to be reliant just on the original records of those materials, but you can provide explanation.
You in fact have to. Yeah. Right. So you in fact have to provide explanation. So you have to detail in your request an explanation of the teaching of or the relevance of the particular information that you're citing. So you'll be in a position where you'll have to explain, in other words.
So let's then, it sounds like we can present a wide variety of different kinds of information as long as it's relevant. That's clearly the standard. Why would you do this? And we talked about cleansing. That seems to be an important aspect. Are there other reasons why you might choose to go down this road? And if so, when?
So the cleansing is the marquee aspect of this that everyone was hyping when the American Invents Act came out with this provision. And so that's a key thing. Beyond that, the idea of a patent holder having the opportunity to present information that someone is saying undermines the validity of their patent, to present that to the patent office and say, oh, by the way, I don't think this is material at all, but I'm submitting it to you, is very powerful, because that in fact gives you the opportunity to get the patent office to agree with you, and then use that to come back to whoever's in whatever context. We can talk about the context. Whatever context of asserting your patent has flaws, and say, well, no, the patent office didn't agree with you. And just to go on, this is something we used to do with reexamination before, where we'd file a reexamination request and we'd say, there's no substantial new question of patentability, so please deny my request. Well, that was a little wonky, because the whole essence of reexamination is you're supposed to be asking for reexamination, and not asking for it. Well, I did that in times and got away with it. Is sort of contrary to what the whole purpose is. So here, supplemental examination actually gives you the opportunity, it's sanctioned, that you could be trying to argue that this isn't material. And it's better than reissue, because reissue, you have to say there's an error. So if people think their patent is perfectly fine, or don't really feel much like saying there's anything wrong with it, this is another avenue to do that. You can just basically, everything's good here, please confirm that you agree, patent office. So those are my thoughts on what you do with it.
And it's also potentially quicker than kind of the old, re-exam process too, assuming that you don't get to a re-exam as a result of this, of the supplemental examination process. I mean, it's a fairly quick turnaround, assuming that you obtain the result you want, which is a finding of no substantial new question of patentability, right?
Yes, that's a big assumption though. so that, we're talking about a good portion, a majority of the time, there is actually a substantial new question of patentability found. Now, that doesn't mean that, that means that the supplemental exam process will end, a certificate will issue that will say an SNQ was found. That doesn't necessarily mean that you'll be rejected, that you'll get an office action rejecting the claims. You could go straight to the notice of intent to issue a re-exam certificate. So you sort of cut straight to confirmation of patentability. But a lot of times, in re-exam, of course, you're going to see rejections. And that can really lengthen the timeline that, that hopeful timeline, which could be quite short. So let's say you had no SNQ found. The decision has to be made within 3 months. But it oftentimes is made within like 30 days. So that's a really quick turnaround. But I think the last time I checked, nearly every supplemental exam filed in 2021 had an SNQ found. So we're talking about a really good chance that it's going to go on to re-exam. And that could be, I mean, if it's a lengthy process, I mean, Mike, you correct me if I'm wrong, but I think you're talking at least a year if you're going all the way to final office action and then up to appeal. I mean, another potentially 9 months after that.
Yeah, I think that's right. I think so. I think the idea is if you're going in with the idea that there's a opportunity to get in and out quickly with a very favorable review, that there's no substantial new question of patentability, you need to be cognizant of the fact that the odds are not great that will happen. And if you still want to try to do that, you really need to be very attentive to the idea of not just arguing that the claims are patentable over whatever this information is, but in fact, they don't raise a substantial new question of patentability. And those issues are different because again, we've said before, you could get a substantial new question of patentability and not get a rejection. So the problem is, if you don't argue substantial new question of patentability and look at the prosecution history that went on in the original patent and try to show that there's nothing new here, you could get the patent office in a supplemental examination deciding that there is a substantial new question of patentability, put you into reexamination, and you take all this time. Whereas if you perhaps were more attentive to the idea that, no, not only is this not doesn't make the claims unpatentable, but there's nothing new here as far as what went on before, you have a better position to try to argue this is no substantial new question of patentability, and maybe a better likelihood of getting in and out quickly. But I think people need to be attentive to that if they want to have that quick in and out.
That's a really interesting point, Mike. I mean, what you're suggesting is that there's an aspect of arguing that whatever it is that you're presenting in relevant information is more or less cumulative of things that have already been reviewed before.
That's exactly the word, cumulative, that you're striving for here.
Excellent. All right. So now, so we talked a little bit about, I think earlier, about kind of how this process may or may not interact with other processes. Are there any exceptions? Are there things that you need to think about in terms of when you might or why you might be filing a request for supplemental examination?
So thanks, Maia. So I can start here, and Mike, you'll jump in whenever you're ready. But so there can be parallel proceedings at the Patent Office, and I think that Mike and I have discussed this before, the interaction and interplay between original prosecution, whether it be via reexamination or some other proceeding at the Patent Office, and for instance, IPR proceedings, where there could be that original prosecution could be used as a basis to argue as patent owner who's being petitioned for IPR that that original prosecution should be viewed as a basis on which for the PTAB to use its discretion to deny institution of an IPR. Now, there's no hard and fast rule there. These proceedings can run concurrently at the Patent Office, at the PTAB, and in the Central Reexam Unit or the CRU. So there's no guarantee, but it's certainly, if you had a denial of a supplemental exam that resulted in no SNQ, or if you went all the way through reexam and wound up with patentable subject matter at the end, or a confirmation of patentable claims, then I think you would certainly put those things forward in your patent owner's preliminary response and urge the PTAB to use their discretion to deny institution on that basis.
Yeah, so I'll jump in because I think that's certainly what you would do. The issue is in an IPR, if you're the patent holder, the question is how likely that is to be successful. And, you have to start with keeping in mind that the supplemental examination is an ex parte proceeding. It's just the the patent holder going back into the patent office and presenting. They're going to present things the way they want. And on the other hand, the IPR is initiated by a patent challenger, and the patent challenger is going to put things in that the patent office wouldn't have seen during the supplemental examination and or a reexamination that follows it, such as a declaration from an expert that will put in fact an interpretation of references or whatever information there is to explain why whatever went on during the reexamination or supplemental examination does not tell the whole story. And when you get all the information, you realize that there really is a patentability issue being raised even on the same or similar basis to what was asserted during reexamination or supplemental examination. So I think the odds are that, when you think about who's going to drive the bus on starting the IPR, that it's a patent challenger, and they're going to be putting things in that the patent office didn't see during the reexamination result or the supplemental examination. The odds are that the patent office, if the position is a good one, is going to institute the IPR.
So in terms of written outcome of the supplemental examination process, is there a substantive decision? I mean, is there will the examiner or present a written decision based on your arguments, or is it kind of a one-liner? What should you expect out of that?
Yeah, so typically it's sort of a two-part conclusion, which is a certificate. So let's say that an SNQ is found. There is a certificate at the end of the supplemental examination procedure, which is actually, it's ending at that point. So the supplemental exam ends at the decision on the SNQ, saying an SNQ was found, and also there's a supporting document that details reasoning behind finding the substantial new question of patentability. And then once the re-exam is ordered, you'll go on with regular re-exam prosecution, with the exception that, it's not the typical re-exam only based on patents and publications, but it can be, it is a full examination based on the basis for the supplemental exam, which can include all these other types of information.
So that actually was my next question was, we've presented now, according to, the standard, all of this new information that normally wouldn't be something that would be the basis of a re-examination, but those things can be considered in re-examination in the event that there is an SNQ found.
Yes, and that is the difference between a re-examination that is the result of a section 257, it's a statutory section for supplemental exam, a re-exam resulting from that procedure versus ex parte re-exam. So it can be a broader basis of examination, and certainly the central re-exam unit, which are the examiners that are responsible for prosecution of re-exams, are also responsible for prosecution of reissues and other cases, and they're skilled at dealing with all manner of rejections and all manner of issues that would arise that form the basis for supplemental exam.
We talked a little bit about cleansing and equitable conduct concerns. Can you do that in the course of litigation if someone's already pled inequitable conduct? I mean, is this a process that you can do in parallel with, for example, a district court litigation?
No.
That's disappointing.
Right. No. Yeah. No. Basically, the statute talks about being able to having a patent not be held unenforceable for inequitable conduct if that information had not been considered or not properly considered during original prosecution was considered during the supplemental examination. However, there are some guide rails on when you can do that. And so if there's a prior allegation, either in a civil action or a paragraph 4 notice of inequitable conduct, then and that happens before the date you file the supplemental examination request, then it's too late. So Meg, why don't you talk about the second exception for cleansing?
So there's a second exception as well, Mike, which, as you know, which is also in relation to enforcement actions. So supplemental exam and any re-exam that results from the supplemental exam have to be concluded before the date on which as a patent owner, your enforcement action is brought. So as you can see, both of these exceptions to use of the inequitable conduct shield are geared toward proactivity on the part of the patent owner. It doesn't encourage a wait and see approach, because if you wait and see, you'll be SOL. So I think that at the end of the day, it is certainly the statutory exceptions certainly make it clear that patent owners should be proactive if they find something that needs to be addressed.
So we talked about it pays to pay attention, is what you're saying.
Mm-hmm.
We talked about the benefits here. It sounds like there are some benefits, but it doesn't sound like this process is without its risks. I mean, certainly one risk is, to your point earlier, Megan, that you're hoping to get no SNQ, but more likely than not, you're going to wind up in re-exam. What are the other risks to this process?
Like you said, you need to be ready for an SNQ to be found. So you need to go into the process, hoping for the best, planning for maybe not the worst, but planning for an alternative. And that means that you need to be ready for the duty of disclosure to reattach, which is something that folks don't often consider when they're going into the process. That you're going into supplemental exam. Maybe you have conduct that you want to cleanse, or it's just a potential issue you want to cleanse. You need to be ready to file an information disclosure statement when you get to an actual re-exam being ordered, and be ready that you're not caught off guard and create another issue of potential inequitable conduct. You don't want this process to haunt you further than maybe you were prepared for. So I think definitely that duty of disclosure reattaching is a huge potential risk that folks, patent holders, need to be prepared for. Apart from that, I think you just need to be ready for prosecution. You're going into the central re-exam unit. It's, as I'm sure Mike probably could talk better than me about, because he was an examiner before, you're dealing with folks who are performing a function of examination. It's not like the PTAB that is adjudicating an issue that's presented. The examiners are, going to fully examine the application, the re-examination again. So that is a risk that you need to be prepared for, that issues may come up as they do in regular prosecution.
And I guess just to amplify those points, if you don't make use of this process, you're not under a duty of candor. So you're sitting outside the patent office with your patent. There's other things that have come up during subsequent prosecution in foreign counterpart case or whatever. You don't have a duty to go back to the patent office, but once you choose to go back to the patent office, and if reexamination does ensue, then you're going to have to, be ready to deal with your duty of candor. And I guess the other thing to keep in mind, which when we talk about reexamination in one of our further podcasts, is that reexamination is not like regular prosecution. There's no continuation practice. And as a result, you could find yourself at the end of the process without a very favorable result and have limited ability to deal with it, contrary to what would happen in normal prosecution. So I think you have to be ready for all those things if you choose to go down this road. And not, it's not like once it starts, you can stop it.
I know we're harping on the duty of disclosure a little bit here, but really at the end of the day, this is a prime interest in using supplemental examination. And it's worth noting that there's a difference between regular ex parte reexamination proceedings and reexaminations that result from supplemental exam in the duty of disclosure. The duty of disclosure as a part of traditional ex parte reexam relates to patents or printed publications and your obligation to disclose those materials to the patent office. The duty of disclosure in connection with a reexam resulting from a supplemental examination is the same as the duty of disclosure during regular prosecution. It extends to all information. So there is a key difference there between those two types of proceedings, and you really need to be aware of that as patent owner going into supplemental exam.
And hopefully as a patent owner going into supplemental exam, you are, insofar as you've given some thought to what information might be relevant to begin with.
Yes, absolutely.
So let's wrap this up. What are your thoughts on this process at the end of the day? Why are you recommending this or not recommending this to your clients?
Okay, so I guess I'll start, and like this is kind of summing up what we said earlier. I think it's a great alternative to reissue because you do not have to say anything's wrong with your patent. You can go in and have information put before the patent office with the goal of getting the patent office to say, yeah, you're right. There's no problem. And that, of course, can be tied to all sorts of activities, such as, you're in a licensing negotiation with somebody and they're, saying your patent's bad, or there's due diligence that comes up and there's some issue, and you can vet all those things. That is an important use of it. The other is a cleansing of inequitable conduct. I think that's a great thing to be able to do so you don't get dragged through the mud if you're enforcing your patent. And I think lastly, for me, if you were going to use this procedure during some other challenge going on against the patent with the idea that you're going to vet this information and have whatever other proceedings going on respect that, you need to be cognizant of the risks, but also attentive to the idea that the standard is substantial new question of patentability. And if you're going to try to say there's nothing here, you've got to speak to that rather than patentability.
So I would absolutely echo those things. I think the two number one use, well, for me, if you have a potential issue of duty of candor, this is the way you go about dealing with it, right? If you have a true issue or potential issue that could result in inequitable conduct and unenforceability, this is a fantastic option that didn't exist before the AIA. So really, when folks were stuck before, they're not stuck anymore. And that's huge. And that may be worth all the time you spend in re-exam as a result of supplemental exam to take care of that issue. And then the other, as Mike said, if you're trying to, galvanize and insulate your portfolio that you're going to maybe go on an enforcement campaign with, then it could be a great procedure, especially if you believe in your case and at the end of the day, you believe that you have patentable subject matter there. I think it's a really neat tool to use, and it's great that it builds on skills that re-exam practitioners already have. So I think it's a great tool.
I would just add, I'm not sure it's as well and heavily utilized as it could and should be. I don't think people necessarily think of it much beyond as a cleansing for inequitable conduct. I think that's what a lot of people focus on. And if they don't have that, they don't give another thought to supplemental examination. And that's a mistake.
Yeah, I tend to agree, especially after this conversation. It seems like it actually could be useful as long as you are in full understanding of the risks that might ensue in the likely event that the process ends up with you being in re-exam. So I want to thank Mike and Megan for your time today. This has been a really great conversation. Thanks also to our listeners. We invite you to join us for our next installment of this podcast series discussing strategy, trends, and other happenings at the PTAB. Our next episode will be covering IP time bars and real parties and interests, two topics that we briefly discussed in our first episode, but we're going to dig into further details next time. Troutman Pepper's intellectual property team helps clients develop and implement global protection and commercialization strategies for intellectual property assets in virtually all industry areas. For more information about how we can help you, visit the intellectual property section of Troutman.com. You can also subscribe and listen to other Troutman Pepper podcasts wherever you listen to podcasts, including on Apple, Google, and Spotify. Thank you, Mike and Megan, again, and thank you for listening, and stay safe.
The views and opinions expressed in this podcast are solely those of the individual participants and not Troutman Pepper or its clients. Troutman Pepper does not make any representations or warranties, express or implied, regarding the contents of this podcast. Information on previous case results does not guarantee a similar future result. Users of this podcast may save and use the podcast only for personal or other non-commercial, educational purposes. No other use, including without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission of Troutman Pepper. If you have any questions, please contact us at Troutman.com.